The Honorables, the presiding judge, and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon. Welcome to your North Carolina Court of Appeals. My name is Judge Chris Dill, and I'll be presiding today. And with me are Judge Murphy and Judge Gore. And we have one case on the calendar. It's O'Brien versus O'Brien out of Mecklenburg County. And we'll first hear from the appellant, Mr. Boutwell. And I understand you want to reserve 5 minutes. Is that correct?
Yes, sir, Your Honor, if that's okay.
Well, you may proceed.
All right. Thank you, Your Honors. May it please the court, John Boutwell from Mecklenburg County. I represent the appellate Kevin O'Brien in this appeal. Just by way of a little background, so this is a domestic case involving claims for custody and child support. And the specific issue on appeal is that arising out of that case, the trial court had entered an attorney fee order requiring Mr. O'Brien to pay attorney fees of a little over $89,000. That was, you're going to hear later, 3 different segments of that award. The first one had to do with custody to the tune of $42,141.50. And the court's explanation for that was based on 50-13.6, found and concluded that Mr. O'Brien had filed frivolous actions and motions and awarded attorney's fees because of that. The second group of attorney fees, if you will, had to do with child support. That was $20,889.50, with a finding and conclusion that Miss O'Brien had insufficient means based on the statute of 50-13.6. The third category was really sanctions in the amount of $25,972 related to Mr. O'Brien's failure to timely update a financial affidavit as required by Mecklenburg County local rules. So those are the 3 distinct areas that make up the $89,000 and some change. So what happened as a background is in 2019, the court had a trial for permanent custody and permanent child support. And in the course of that trial, it was found that Mr. O'Brien failed to timely update a financial affidavit. So what the court did is it determined it was going to sanction Mr. O'Brien in an amount later to be determined. It went ahead and entered a custody order, a permanent custody order, and a temporary child support order. A little bit down the road, it then entered a permanent child support order. And then in 2020, Mr. O'Brien changed attorneys. We're coming up on this attorney fee hearing in June of 2020, asked for continuance, that was denied, proceeded to have the hearing. And so the temporary order and the attorney fee order were the orders that were appealed. Now, before we get to those 3 areas, there in our brief, we raised the issue with the admission of evidence. So what happened is Miss O'Brien and her legal team decided on a certain process for getting information to the trial court. And what they did is they presented, it's sort of hard visually to see, but it's about a 5-inch binder of over 700 pages of documents, including a 12-page timeline. Miss O'Brien testified, and she hits on parts of the timeline. She identified, I believe it was 7 out of the 43 exhibits. When it came time to admit those, well, first of all, her own attorney even stated that there wasn't enough time to go through everything in the documents or the timeline. So when they offered it for admission, Your Honors, we objected. And specifically with the timeline, we objected that there wasn't enough time to read through all of it. There wasn't enough time to cross-examine Miss O'Brien about it. There wasn't enough time. She'd even testified about all of it. To that objection, what the trial court did is it decided it was going to give Mr. O'Brien a couple extra days to review that timeline. So on a preliminary basis, it admitted the timeline. And as the transcript reveals, the trial court was not inviting arguments from Mr. O'Brien about the evidence, but simply wanted to make sure that the timeline related to reflected like dates of when documents were filed and spelled documents right, etc. With regard to the over 700 pages of documents, the court went ahead, even though we objected that they were not introduced or identified or authenticated, it went ahead and wholesale admitted those 700 plus pages of exhibits. And the problem with that is and the prejudice comes from, if we'd have been able to go through everything, I think things would have been far different as we get to those three distinct areas. I'll foreshadow one of them if I can. For example, the court, when it found that Mr. O'Brien had engaged in frivolous actions, it cited to two motions to quash, actually three motions to quash subpoenas. Well, as it turned out, when you dig through all the documents and you go through it, there were actually orders entered on those that granted his motions with respect to that case and found that good cause existed. So there were a lot of things that were packed in that even the court missed out on based on the way this was handled. We believe, Your Honors, that what happened ended up being a violation of Rule 901 because that sets as a condition under our evidentiary rules that documents have to be identified or authenticated prior to admission. It also, we believe, violates at least the intent of Evidentiary Rule 1006 that deals with summary and how to treat backup documents. Now, 1006 tells us that the document should be made available at a reasonable time and place, but it doesn't flesh out what that means. The federal rule is substantially similar, or I think it's identical to the North Carolina rule. There was a Fourth Circuit case we found, the Streisel case, that interpreted 1006. And in construing it, they said two things. Number one, the underlying evidence or documents must be admissible. That takes you back to other evidentiary rules like 901. But number two, they must be made available for cross-examination. The problem we have with the process is that under the specific facts of this case, the court had set a 2-hour hard stop on this trial. It gave both sides approximately 50 minutes each to present evidence cross-examined. And with a 12-page single-space timeline, over 700 documents, there wasn't any time to do that. And that's our problem with the overall process.
Mr. Bell, let me just narrow in a little bit on kind of the authentication and 901 issue. Can you give me the transcript page where it's objected to on those grounds?
Yes, sir. Let me see. So I have that it's on page 40 of the trial transcript. Judge Murphy, that the objection was lodged about it not being introduced or identified.
I see where there starts to be an objection. Looks like it's at around T40 where Father's counsel starts to say that is fair to say, and I did want to. I don't want to jump ahead of you because I know we're on 1000, but I have a separate objection with the exhibits that were not testified about. And then the court cuts trial counsel off, but I don't see where Father's counsel at trial ever came back to lodge an actual authentication objection. I understand that may have been where he was intending to go at that point, but before or even shortly after 1 through 40 and A through B come in, I don't see that objection made to preserve it for appeal.
I think my notes, and Judge Murphy, apologize if I'm wrong. So I believe this dialogue started on page 38 of the trial transcript, and I believe it continued on to page 42 and 43. My recollection is when I lodged the objection, I don't recall using the words authenticate, but I do recall talking to the trial judge about, wait a minute, she's only identified, and then I listed the specific one she identified. And I think that's where the objection was. And I believe those are in pages between 38 to 43.
Okay, that's where you're specifically talking about I heard in Ms. O'Brien talk, I heard exhibit 2, 6, 10, 11, 12, then A and B. Is that
Yes,
what you're
sir.
looking at?
Yes, sir.
Okay.
Yeah, right.
All right.
If that helps, yeah.
Thank you, sir.
Yes, sir. Now the substantive areas, once we get past that, is the first one I'll deal with is insufficient means. So 50-13.6 in a custody child support case, one of the grounds the court has to find is that Ms. O'Brien had insufficient means. And it seems like our cases say the guiding principle with all this is this question: is an award of fees necessary to enable Miss O'Brien to meet Mr. O'Brien on substantially even terms, to make it possible for her to hire legal counsel? And you see that in different permeations throughout the cases. And so when you flesh that out with the facts of this case, Your Honors, we get this, that they're both attorneys. Miss O'Brien's a trial attorney. Mr. O'Brien's a patent in-house attorney. Mr. O'Brien makes a little bit more income, but they're similar. Miss O'Brien was earning $240,000 a year at the time of this hearing. And the evidence showed that she kept up a pretty lavish lifestyle. While she's paying an attorney, she's spending $30,000 a year on vacations. That includes Italy, Belize, ski trips to Idaho and Montana. She's spending $1,500 a month to go out to eat at restaurants, $1,200 a month for grooming. I'm sorry, $500 a month for grooming, $1,200 on clothing. She's contributing to her retirement. She testified she's not on a tight budget, and she testified that she was able to pay her attorney fees on time, all while keeping up this lifestyle. Now, to be fair, later her attorney redirected, and she pulled back a little bit and said, well, maybe I don't pay him all the time. I mean, I'm sorry, I don't pay him on time every time. But the evidence was she didn't owe a dime in attorney fees at the time of this attorney fee hearing. She was called up. She was paid up. And contrast that to Mr. O'Brien, and he presented a document. He owed his trial attorney, his prior attorney, over $60,000 at the time of this hearing. And just think about the guiding principle. It's like, what's fair? Is that award necessary to enable her to meet Mr. O'Brien on even terms? And I think the resounding answer is no.
Is there a requirement in making this determination as to what his means are to help pay for her? I mean, does the court
I'm not aware of that.
So there's no requirement that the court's got to find that he's got the ability, he's got the excess cash flow to make to pay this money?
I'm not aware that there is. When you look at the attorney fees, it's almost where it's focused on her. The court can, but is not required to consider both of their estates.
Even if he had nothing, the court could enter this order if she just shows I don't have enough. He could earn zero, and the court could. You're telling me under the case law, the court could order this attorney's fees because they don't have to consider anything about him.
And I think that becomes problematic if you don't, right? Because down the road at a contempt, it becomes an ability to pay argument.
I think one thing you say is the court didn't adequately consider her estate, like not what she makes, but what she had. And you're saying they didn't include the marital property, her share of the marital property, because of this language in our case law that talks about the quote separate estate. Is that correct?
Right. So yeah, our argument is a couple things. First, that she had enough income, considering her income and lifestyle, to pay her attorney, consistent with testimony.
Was there any evidence that her separate estate or whatever was depleted at all during this time frame that she was able to pay her attorney's fees?
Yes, contradictory evidence. Okay, so Ms. O'Brien presented a chart, and her chart stated, well, first of all, she testified that Mr. O'Brien had given her, during the litigation, $200,000 distributable award. And she testified that she had to use part of that award to pay her attorney's fees. She then introduced a chart, and the chart doesn't say that. The chart says that she had to use part of her distributable award to pay her taxes, not attorney's fees.
Now, was this replenished? Was this replenished when he caught up on his back child support? Was his failure to pay back child support timely? Is that what caused her to go in the hole? But did she catch up? I mean, I don't know what the evidence showed.
I don't think that evidence was before the trial court, Your Honor, about the timing of that.
Okay.
But what's interesting is a lot of the cases like Rickard, McLeod, they focus on liquid cash. And Miss O'Brien had at least $255,000 in liquid cash at the time of the attorney fee hearing. 73,000 of that was from a checking account. But she didn't have to use that because she was paid up at the time of the hearing. You hit the nail on the head about the estate. So if we get past the income, we get to the liquid cash, and we start looking at her estate, I'm not sure we get there, but the question is even if she showed it and had to deplete it, was that reasonable or not? And that's where the Taylor, the Parsons cases come in. You know, you can reasonably deplete the estate to pay attorney's fees. It just can't be unreasonable.
Well, my question is, was there evidence that she used to have 300,000 and then she only had 200,000, or did she not put on any evidence as to what her how much cash she had before she paid this? Because what did she pay, like 100 some thousand, and y'all were ordered to repay her 89 of it? Is that correct?
Yes, sir. I think her ask was like 115,000, and the judge made like an 89,000 award.
So had her liquid estate depleted by $115,000. I mean, or was she able to pay it out of her cash flow? I'm just trying to determine, did she actually pay it out of her cash flow? Right. Or did the evidence? What did the evidence show? Or is it hard to say?
I think it's hard to say. We believe her testimony showed she was able to pay it out of her income. She testified that she had to use part of this 200,000 distributive award, but I don't think she ever showed documents to link that up to the distributive award.
Okay, go ahead. You can continue. I'm sorry.
Mr. Boutwell, let me ask you before we move on from that. Looking at finding fact 15 on record 286, it says the assets in mother's possession appears to be, in the present tense, $648,600.
Right.
Is that a calculation after she has already paid those attorney's fees? This is still assets?
Yes, sir.
I think, at the time of the hearing?
Yes, sir, because there was no evidence that she owed attorney fees at the time of the hearing, and that's what the 648 figure is, what she said was her existing estate at that time. So I assume that's after she paid her attorney's fees. To Judge Dillon's comment, we believe that finding's in error, Your Honor, because it did not account for two significant items of real estate. One was a marital home, and the tax value on that, which we all know is conservative, was in excess of $1 million. The second one was a beach home.
Was there a lien on the house, or was it paid for?
No, there was a mortgage on both of those.
Okay, well, that makes a difference. I mean, was it fully leveraged? I mean,
no. And Mr. O'Brien produced a chart to show those both of those assets and both of the liens on both of them. And when you use his chart, which is the documentary exhibit number 783, it shows her estate goes from that 684 figure to like a 1.4 million figure.
Okay.
So even when you include the liens, it's a significant jump up in estate. So those are the issues we have with the insufficiency that the judge determined that she had. We don't believe the evidence shows that, and it's not in accord with our law on that. The second substantive item, Your Honor, has to deal with, and this is where I think it gets interesting, frivolous action. So under 50-13.6, as you guys probably know, there's one sentence and a two sentence. The second sentence, the second part, the second clause of that second sentence is where this language comes in that authorizes the judge to award attorney fees if a supporting party has initiated a frivolous action. And so what the trial court did is said he believes Mr. O'Brien engaged in frivolous actions and motions, and he decided to award custody fees because of that. I mean, the problems we have are two things. The first is the legal precedent of stand back, and the second one is the findings are undercut by the judge's own example. The stand back case, when it went up on appeal, the husband in that case was ordered to pay attorney's fees, and he made an argument to the Supreme Court that says, wait a minute, a trial court has to find that I have not provided adequate support before you can hit me up for attorney's fees. And the Supreme Court dealt with that by saying, well, no, because this is a combined custody and child support case. That second part of 50-13.6, that second sentence only applies in pure child support cases. The Supreme Court then stated that the legislature did not intend that second sentence to apply to both custody and support actions. And then the Supreme Court ended up by saying that the second part of the statute is inapplicable to custody and support cases. So here, the O'Briens have a combined custody and support action. They both filed competing claims for custody and child support. They both litigated those claims. Both of those claims were heard by the trial court. You have court order on both of those claims, custody and child support, and the court's order on attorney's fees reference that. And the problem is by awarding fees based on a frivolous action, in this case, is in violation of standback. Now, the issue is that I have to acknowledge to all three of you is that puts my argument with standback puts this on a collision course, if you will, with 3 Court of Appeals cases of Doane, Wiggins, and Durham County. The only one of those cases, Doane, mentioned any part of the argument I'm making. The husband made that argument. The Court of Appeals briefly referenced it and then said, well, you're presenting a child support argument, so we can do it. But that was also a combined custody and child support case. Wiggins and Durham County, nobody made that argument. I think the reason why, if I may be so bold, that the Court of Appeals didn't pick up on standback, maybe, if you look at the briefs for those 3 cases, nobody ever cited standback, nobody mentioned it, nobody argued it. It just went unaddressed. And we believe this was a legal error and has to be reversed.
So you're saying because your case involved child, it was made under custody, it doesn't apply. It doesn't apply to custody matters.
That's right.
Okay.
That's right.
And the court specifically found the frivolousness was based on the custody aspect?
Yes, sir. Yes,
okay,
sir.
so you're saying standback stands for the proposition that the court could not do that under. Now, what if we find, okay, it wasn't frivolous? Would that drop then into, well, if we find that Ms. O'Brien couldn't pay for her own, why wouldn't it go, would it drop into the other category that she couldn't pay for it and she did it in good faith?
Right. Well, I think in theory, yes, that could happen, right?
So we'd still have to evaluate on that piece in any event. Okay.
And the court was specific. If you look at the orders, it has categories of frivolous action due to custody. And then it has a category of child support and talks about insufficient means. And it has a third category for sanctions.
Doesn't make a finding that there was anything frivolous about the child support. Is that right?
If we look at on the order, Your Honor.
I can go back and look at it. I just didn't know if you knew that. Go address your sanction argument because you don't have a lot of time. I want you to.
Yes, sir. Yes, sir. Okay. I'll jump to the sanctions. So on the sanctions part, what we have here is that the judge ended up ordering over $25,000 for sanctions. And it cited 3 rules, and that was the 3 rules that was argued by Miss O'Brien's attorneys. And the rule was Rule 11, Rule 37, and then the local Mecklenburg County rules. And if we look at Rule 11 doesn't apply. We cited to the Williams v. Hinton case where that involved a failure to do something, failure to notify, I think, the court of a conflict for calendaring purposes. And the court fleshed it out a little bit and says, Rule 11 is not meant to remedy everything. Finally, failure to timely notify is beyond the scope of Rule 11. Here, the trial court was very specific. Its frustration with Mr. O'Brien, which things snowballed from that, was he didn't update his financial affidavit. He failed to do that action. Rule 37 doesn't apply. It's not a discovery dispute. And so the only rule that we can fall back on is the Mecklenburg County Local Rule 22, which does allow for sanctions. And it's a 2-parter. It says, as long as allowed by law, and then the second part, and deemed appropriate at the discretion of the judge. And so that the as allowed by law, there has to be some other law to justify the attorney fee sanction under our Rule 22 of Mecklenburg County rules. And there's been no other law identified, argued. The only other laws cited were Rule 11 and Rule 37, and those don't apply. So we believe that was an error too.
Well,
you know,
let me ask you this real quick. I'm just looking at the interpretation of this local rule. You know, attorney's fees are allowed by some of our laws as sanctions for violating an order, violating other rules. Why would we not look at this as globally including, you know, any other possible sanctions? Why does there have to be another statute or another rule specifically setting out attorney's fees?
I think you're right. If the rule were written differently, Judge Murphy, I mean, you're right. If that Rule 22 says the court can sanction including attorney fees, then we might be somewhere different. But it specifically is written. It says it's allowed by law. Now, it may be the way that's written is because we have plenty of case law out there that says that attorney fees have to be specifically authorized by statute in North Carolina. And this is a local rule, so maybe the drafters thought we need some other underpinning to justify it. I don't know. I mean, if we get past the substantive arguments, we certainly made arguments about the reasonableness of the fees, but that would be subsumed by the more substantive arguments, obviously, if you ruled in Mr. O'Brien's favor.
Counsel, you're about to run out of your time here, but Judge Dillon's time, I want to ask one question on that.
Go for it. That's fine.
Is there a scenario in which that there could be a violation of a statute that doesn't anticipate a sanction, that Rule 22 obviously would be a catch-all within the judge's discretion to use as a sanction? So if it's allowed by law, but that particular statute doesn't anticipate, you know, a sanction, is that a scenario in which the judge would have the discretion to use the local Rule 22?
I mean, objectively, I mean, perhaps, Judge Gore, I mean, I think that, you know, it does say, I mean, all I can go is what the wording, right, of that local rule. And it just says, you know, sanctions is allowed by law. And I think the way it's written, there's got to be some other basis that triggers the judge's discretion under Rule 22. I know that can be frustrating because if you're on the other side of things, you know, you want the judge to be empowered. I get that. It's just problematic the way this was set up and justified.
Well, I appreciate it.
Thank you, Your Honors.
Okay, we'll hear from the appellee.
May it please the court, my name is Leonard Kornberg, and I'm from Charlotte, and I represent the plaintiff appellee. It is our position that the court appropriately awarded attorney's fees. The amount of the attorney's fees obviously is not, there's no disagreement. The amount awarded was $89,003. That amount equaled $42,141 for child support, or I'm sorry, for child custody, child support $20,889, and sanctions $25,972. If you actually do, there's a lot of talk that goes on during the hearing about the percentage of the estate versus the amount of attorney's fees, but my client spent at least $115,202 in attorney's fees, and the amount that was awarded was $89,003. So that means that she actually received 77% of attorney's fees. There's some talk about 17.8%, but it's our position that the amount awarded was 23% less than the sum requested. I take as far as the one thing that I think it's important to point out to the court that is that facts matter, and Mr. Boutwell is 100% correct that both parties were attorneys And I would submit to the court that that requires some additional effort on the part of the individual to act appropriately when he's filing a lawsuit. If you go through this record, Mr. O'Brien's actions throughout this lawsuit has been replete with frivolous filings, arguments made in bad faith. His own counsel admitted at times that Mr. O'Brien didn't do things correctly.
Ms. Kornberg, is there any case law or statute that would hold a party to a higher standard in any type of case based on their profession?
There isn't, but I think that when you talk about the reasonableness of an award of attorney's fees, you have to take into account all the factors. And I think one factor that the court can look at is the fact that Mr. O'Brien repeatedly filed documents that were verified when he has exclusive knowledge about the actions that he took and the consequences for filing a verification on any document that is false. And we would submit to the court that at the very least, the trial court found that Mr. O'Brien acted negligently in his actions to ensure that we're mincing words. Mr. Boutwell is mincing words when he talks about a failure to update an affidavit. The failure to update the affidavit means your numbers are wrong, because there were 3 affidavits that were filed, and there was an admission by Mr. Bush that the affidavit that was filed was the numbers were wrong. Well, if your numbers are wrong, then of course the statement made about that the numbers weren't updated is tantamount to being, in this instance, that the numbers were wrong, that his numbers were incorrect.
Are you saying that's about that? Are you talking about the sanctions? Are you saying so therefore
about, yes, in terms of a violation of a Rule 11?
So Rule 11. So
correct.
is there any dispute between the parties that if there was a violation of Rule 11, $25,000 was the appropriate amount because that's what was spent because of the misrepresentation of the amount? Is there anybody do y'all argue that 25,000 is there any argument that 25,000 is not the correct amount?
No, that is the court ordered the entire amount that was due as a result of the failure of Mr. O'Brien to ensure that his paperwork was correct.
And y'all put on evidence that amount was 25,000 and
Correct.
found that.
Yes.
Okay.
If
What
you
about
look-
the go
sorry,
ahead. No, guys, what about okay. Well, just continue on because I want to hear about the other stuff too, because the child support had nothing to do with anything wrong that he did. It was just and then the child, and then the argument the custody doesn't apply because of stand back. I'd like to hear how you respond to those.
Stand back. I took a lot of time reading stand back and also reading Doan and the
Wiggins,
the Doan and the Wiggins case.
right.
There is a fine distinction that can be made, and you have to read it closely. But if you pull stand back up and you do a word search with frivolous, the word frivolous doesn't appear in the stand back case. What the stand back case was referring to was and I even quoted it. If you look at stand back, the court said in stand back, before ordering payment of a fee in a support action, the court must find as fact that the party ordered to furnish support has refused to provide support which is adequate under the circumstances. That's what their concentration was in terms of awarding of fees. It had nothing to do with the semicolon, the sentence after the semicolon. And I'm not an English major, but if you look at Doan, and if you look at Wiggins, their concentration was on the language after the semicolon. It wasn't on the failure of the individual to provide support. That is a fine, that is a needle fine distinction, but that is a distinction enough upon which that I would submit to the court that this notion that somehow we're trying to speculate what two previous panels of this court decided, and somehow infer that they didn't know the law, I would contend is mildly insulting. I know that this court does a fantastic job of making sure that the case law, making sure that decisions are made based upon the case law, and sometimes the decisions are made when the parties didn't even necessarily brief an issue. I've seen that happen. So I think it's speculative, and it's unfair to those panels to contend that somehow they unknowingly made a decision that was in conflict with the Supreme Court. That's a stretch, especially when you consider that there's another reasonable argument, that being that in the Standback case, the Supreme Court was relying on the first sentence prior to the semicolon, and in the Court of Appeals cases, they were relying on the frivolous nature of the action, because I do agree that if the language was the same, there would be a conflict in the cases. But the language that each of those courts concentrated on was different. And not to mention, I would submit to the court that those two cases, which are, a Standback was decided in 1975. The other two cases were decided in the 2000s. So those cases were decided after Standback, and they are still good law. So I would submit to the court that they have presidential value, and if there is some issue with there being a conflict, then it's incumbent upon that this court, that the appropriate action is to apply the law of the Court of Appeals, and if Mr. Boutwell thinks it's in conflict with the Supreme Court, then he can do a writ of certiorari, or if someone doesn't agree with, if one of your honors don't agree with me, then he can have that bite at the apple. But as far as, and it's not just one panel, it's two panels. So it's not, it would be rank speculation to believe that these courts just didn't know that there was this case out there that conflicted with their decision.
Mr. Kornberg, let me just see if I can summarize your point on that real quick, is that to the extent Standback discusses anything after the semicolon, based on what it's deciding, that would be dicta, and in re civil penalty would require us to follow Doan and Wiggins as controlling holdings.
That's correct. Yes.
Even if that's the case, let me ask you about valuation of attorney's fees and what they apply to.
Yes.
Is 13.6 just the second part? I just want dealing with the frivolous nature. If you file one frivolous motion, one motion in 3 years of litigation that the court finds frivolous, are you entitled to all your attorney's fees for the entirety of the action? Or is it only in relation to that frivolous filing?
To answer your question, I would submit to the court that if it was a limited situation, that a trial court should concentrate on that issue. But this is not a situation where the action of Mr. O'Brien was limited, and therefore it takes it out of that particular arena. This was a situation where it was continuing. Even Mr. Boutwell, in terms of his referring to these orders, if you read these orders that weren't, if you read the orders indicate that certain portions of Mr. O'Brien's motions were that they granted relief, but the court had strong issues with other portions of the requests. These were requests for discovery, and although you may be able to depose a person, when you ask them to provide X, Y, and Z in addition, and they're not entitled to X, Y, and Z, even under Rule 11, a motion or a pleading could be partially frivolous. It doesn't have to be entirely frivolous. I mean, there's three.
Is there such thing in our case law regarding a motion to partially quash a subpoena? Don't you typically just move to quash a subpoena in total, and then the trial court draws the lines with a protective order if it's only as to a portion of it?
Well, there were certain things that were asked for as a result of the subpoenas, certain requests that were made, if you read the orders, that were not granted. So although they were allowed to do the deposition, they weren't allowed to get certain documents. The issue that we would contend was not the deposition itself. The initial issue was the documents. And obviously, if you can't agree on whether someone is going to provide the documents, you're going to file a motion and you're going to ask for the documents and you're going to ask for the deposition. They got the deposition, but the real issue was the documents in a lot of these circumstances. Mr. O'Brien contended that because of his security clearance, because of what he does, he shouldn't have to turn certain things over that were entirely unrelated to anything related to national security. So, I mean, these are the arguments that were repeatedly made. And I apologize. I know I'll let you ask I apologize.
It goes along with that. And if we find even just one of these proceedings to be non-frivolous, don't we then need to remand it for a redetermination of the attorney's fees that apply to those that we do uphold as being frivolous?
I would submit to the court that because the court was so specific in making findings as to what the court deemed to be problematic, unlike other orders I've seen where there isn't that specificity, that wouldn't be necessary, because the court provided a lot of specificity regarding the allegations that were made and the motions that were filed that the trial court deemed to be problematic. Mr. Boutwell makes arguments about findings that the trial court never made. And again, that's speculation. That's his belief. That's their belief regarding what findings a court should make. But the court made the findings that it did, and it was quite specific in the issues that it found to be problematic in terms of the frivolousness of what went on throughout what I would contend to be the entirety of this case.
Well, let me ask you that. Is that limited to what we see in finding of fact 10G 1 through 3? The trial court uses this broad language, including but not limited to, and just lists these three things. Is that all we're looking at for frivolousness, or do we also need to be looking back at those in finding of fact 6? The trial court doesn't incorporate anything by reference and uses this language. If the trial court's meaning that other things were frivolous, doesn't that need to be included in the actual finding?
Well, I think at least by reference, the court references the unreasonable positions that he took not only the motions were frivolous, but the positions taken within some of the motions were frivolous. From the get-go, Mr. O'Brien contended that he should have custody and that Miss O'Brien should be paying him support. I mean, that's where we started from.
Well, if
That-
he ended up with sole custody,
Let me jump in for a second.
would have
real
support.
quick
Yeah,
on
go ahead,
that
Judge.
issue, if you don't mind, Judge Murphy. I guess every attorney can make an argument. So I guess where is that fine line, and where is the case law on flushing out that line, Mr. Klumberg? Because it's kind of like being pregnant. Either you are or you aren't. And so either the whole thing is frivolous, or either it's just bad lawyering. So where are we at having a situation of where this is bad lawyering, or the whole thing is frivolous? Because it's hard to split hairs in the context of what I think you're saying that the trial judge did and the trial judge tried to. But I'm seeing a lot of bad lawyering by him.
Yeah.
But where is that fine line between clearly being frivolous and it being bad lawyering?
Well, I would compare it and I would compare it a little bit for a lawyer to pornography. You know it when you see it, quite frankly. And keep in mind that this is where we lead back to Mr. O'Brien being a licensed attorney in the state of North Carolina. So if you look at the case law regarding Rule 11, it doesn't impose a burden on a party that relies on an attorney who makes a frivolous argument. But because in this instance, Mr. O'Brien is an attorney, I would impute the bad lawyering that occurred in this case, the rather unnecessarily aggressive lawyering to him, because he knows better. He's a lawyer. He's not a layperson. So the standard, if you go back and you look at Rule 11, and if you look at the standard associated with that lay people are treated differently for purposes of what a court can hold them responsible for. I think that again, facts matter. And in this instance, he is a lawyer. He allowed this to occur. He knew, he had special knowledge. And not only that, he put his hand on the Bible and swore to the very same laws and the very same Constitution that we did and that his lawyer did. So he had some degree of
Well, I guess let me talk about speculation. So in finding of fact 6A, where the judge pretty much prior to any pleadings doesn't have an idea of what the facts are, and if they do, then they're conflicted out. I would feel, but basically saying that he didn't have a snowball's chance in that pleading. That's basically what I garner from that finding of fact. So, but if there was 5% of fact in there, where is it become where it's completely frivolous and he's just swinging for the fence on that 5% of him having a chance to get that level of custody that, or I guess I'm asking, what is the measuring stick that we're using?
Well, keep in mind that in Mecklenburg County, we have the one case, one judge rule. So this judge was the judge from the inception of the lawsuit up through the hearing. So this judge knew everything that occurred. At the time this attorney's fees order was entered, the court had the benefit of a child custody hearing, of all the pretrial actions that both parties took. And it also had the benefit of a child custody trial that lasted close to 2 days, and a partial temporary support hearing, and then a permanent support hearing. So the court had at that point probably had a pretty good idea of what it saw the pleadings were versus what ultimately panned out.
So are we looking at more of a frustration with this court with the bad lawyering, or are we looking at there being a little bit of meat on the bone for this pleading to be made, and or it just wasn't there? Because if you're able to sit here and say, Judge, he had no facts in that pleading that were valid, none, then I see your point of it being supported as being frivolous. But if there was two finding or two, requests of 20, where do we cut it off as being completely frivolous or not?
I don't know if this court was saying that everything, that the trial court was saying everything was frivolous, but there's minor allegations and there's major allegations. When you allege that you're entitled to child support and you don't have a snowball's chance in hell, excuse my language, of getting it, then it's frivolous. If you allege you're entitled to custody and you wind up full custody, primary full custody, and you wind up that the amount of dissension in the relationship is so bad that one child basically won't have anything to do with his dad, doesn't want that is a major, that is a fundamental issue with the pleading. That wasn't a minor allegation about a date or a time that's wrong, or an instance that could be that anyone can make a mistake about. These are major material allegations that were made that turn out to be entirely inconsistent with the facts of the case. And the one thing that I think it's important, because I think my time will run out, well, I still have little time, but keep in mind that in this case, we had a situation, and this gets back to the insufficient means test. In this case, we had a situation where Mr. O'Brien didn't pay a dime of child support, of cash child support, from the inception of the lawsuit until the permanent support hearing. Although he was ordered to pay earlier temporary support, when the court continued that, he still hadn't paid that amount up through the date of up until the morning of the permanent support hearing. So when Mr. Boutwell talks about her needs, firstly, if you read the case law refers to her needs at the time of the hearing, and everything is relative. We live in a world where not everyone, where there are inequities in what people earn. And that's just the nature of our society. So what's reasonable for Mr. and Mrs. O'Brien in terms of their expenditures may not be reasonable for someone who earns significantly less. But the case law refers to what one's reasonable needs and expenses are, and it refers to that at the time of the hearing. And when you look at that, you look at that for a significant time throughout this litigation, Miss O'Brien had a significant, the amount, firstly, even because she wasn't receiving child support, her needs and expenses were significantly higher than her net income. And the court makes a finding about that. The court finds that the amount that her needs and expenses were far surpassed her reasonable needs and expenses, far surpassed what her income was. If you look at finding, it's page 286, 285, 286 of the record, it talks about mother's income and estate. And mind you, these findings were part of the permanent child support order, which was never appealed from, that her net income was $14,077, and that her monthly expenses were $19,063.21. She had a monthly deficit of $49.86. If the money to pay her attorney's fees came from a savings and checking account, as a result, if you read the record, what winded up happening, because Mr. O'Brien refused to give her money, and ergo the interim distribution, the motion for an interim distribution had to be made, that she winded up significantly changing her withholdings, which ultimately led to her having a $150,000 tax bill. She basically financed her attorney's fees by not paying her taxes, is what occurred, because she didn't want to liquidate these assets, because if she liquidated the assets, there would have been a significant tax burden. So is it fair under these circumstances to require that my client have to liquidate IRAs or other withholdings, thereby enduring some significant tax burden when Mr. O'Brien refuses to pay the child support amount that he owes? And therefore, she doesn't have the money to pay child support, and there's a cascading effect. She has to change her withholdings so she can then pay her attorney's fees. She was basically robbing Peter to pay Paul, is what was occurring. And whether you change your withholdings, and if you have a $150,000 tax bill, or you take $150,000 out of savings, it leads you to the same place. You have $150,000 less than you otherwise would have, or $115,000 less than you otherwise would have, but for the fact that you didn't have to pay these attorney's fees. So to say that there wasn't a reduction in her estate is I think a little bit disingenuous, because in essence, if you read the testimony, there was.
Now, does he get credit for the fact that he replenished her estate by paying the back child support?
Well, I would contend
Let me
not.
just say real quick, I have no idea how much time you have left because I don't see the clock on my screen.
I have
so
1 minute. I have 1 minute.
So yeah, I'll give you a couple of minutes because
I would contend not, because she was paying the attorney. At the time that he gave her the money, the litigation had almost ended. On the last hearing in this matter, other than the attorney's fee hearing, he paid on the day of the last hearing in this matter. And for 2 years, my client did not receive child support. And each month she had to pay the James McElroy deal a lot more money than I make per hour. And I'm not saying it's not deserved, but but Jonathan Fite certainly didn't allow her to ride and with that money. That had to be paid each month. And each month she had to pay, she had to finagle her withholdings or take money from an interim distribution in order to do so. The other thing is, Mr. Boutwell
I'll give you 2 minutes. I'll give you 2 minutes to wrap up. So go ahead.
Thank
I'll give
you.
you 2 minutes to wrap up.
Thank you kindly. Mr. Boutwell speaks about the residences, which were not at that point. There's the equitable distribution matter as of the date of this hearing was pending, and Mr. O'Brien had both residences, whatever the equity was in them, in his possession, and was renting them out and earning rental income. So my client didn't get the benefit of those residences or the rental income as of the time of the hearing. In addition to that, the case law, and I cited this in my brief, talks repeatedly about, and I don't know if they just use the term inartfully or intentionally, but the case law talks about one's separate estate. And as domestic lawyers, when we talk about one separate estate, that's in reference to what money you have that's not marital. My client had no separate estate. The only money that she had was marital funds. And that is where the attorney's fees were being paid from, is her marital funds. I don't know. I would submit to the court that maybe some clarification of that word would be somewhat helpful, because it may be to a domestic lawyer somewhat misleading in terms of, do you mean the assets in her possession at that time, or do you mean her separate estate? Because even if you read the statute in terms of what separate estate, that basically means something that is not marital.
I understand.
Yeah.
Yeah. So, well, you wrap up real quick.
Okay. In closing, I would submit to the court that the trial court did not err, and that the entire sum of $89,003 was appropriately awarded. And
Thank you so much.
I thank the court for its time and attention.
Thank you so much, Mr. Bowell. You have, I'll give you 5 minutes for rebuttal.
All right, thank you, Your Honors. Thank you, Mr. Kornberg.
Let me ask you a quick question. You said that Rule 11 doesn't apply. Why not? Because Rule 11 says that they can impose upon the attorney who signed it or a representative party or both the sanctions. So I'm trying to understand why Rule 11 doesn't apply.
Right. Our argument, Your Honor, was because it involves conduct not associated with, when we think of Rule 11, we think of an attorney or a client signing off on a document where there's no basis in law or fact. Here, the judge was very specific. The sanction was due to Mr. O'Brien's failure to update a prior affidavit. That's what he was mad at Mr. O'Brien for. He was not mad at, oh, you presented this new affidavit that's full of errors and I'm going to sanction you for it. It was the failure to do something. That's why.
Okay. So he didn't sign. Okay, I got you. I understand your argument. Okay, go ahead.
Real quick on that issue, I'll be fast. Wouldn't the attorney's email need to satisfy Rule 11, or is that only going to apply to things that are filed? Because if I'm understanding the local rules, if they're going to rely on the old ones, they basically have to say there's been no change since the last affidavit, and that's something that the attorney could have communicated to the other side. So why wouldn't that disclosure and a signature line in an email count for Rule 11? Is there something there I'm missing?
I don't know that you are, Judge Murphy. I mean, what's interesting though, what the trial court didn't go there. The trial court focused on the failure to timely update. It didn't focus on a separate correspondence from his prior trial attorney to Miss O'Brien's prior trial attorney.
Thank you.
I wanted to point out a couple things, if I can, Your Honors, and certainly you interrupt me as always, but a couple things that stood out to me from Mr. Kornberg. It's this whole notion of you focus on separate estate or marital estate. I would just suggest the court, if you look at the case law like Taylor, when they're looking at these, they do use the phrase separate estate, but it's pretty obvious when they're going through the analysis of what a wife has, they're tallying up everything, including the marital estate. And that distinction was certainly not made at the trial level by Miss O'Brien. The other thing I want to point out is that level of detail we just heard from Mr. Kornberg about the changing of withholdings and what she did to take from this pot to pay this pot. That was nowhere, I don't think, fleshed out like that in the court's record. In fact, but my understanding is he said that she did that so that she did not deplete her estate. Well, I mean, her testimony at trial was, at least in her chart, was she had to deplete her estate by 17.something%. So I don't know which one's accurate, which one not, but I think that's pretty problematical at this late stage that we're getting a different story. He talked about Mr. O'Brien not paying cash child support. That's true. I'm not going to hide from that. He was paying a heck of a lot of money in private school tuition and expenses along the way. Now, over and above that, was he handed her cash child support? He was not. And we don't take issue with that finding of the court. I think, Judge Gore, you hit on something when we're talking about what point do we draw the line between making an argument, advancing a position versus being frivolous. And you asked Mr. Kornberg about that 6A in the court's finding. Well, and we fleshed this out in our brief. Not only Mr. O'Brien and Miss O'Brien testified this, but the counselor testified that as respect to their daughter, the daughter told the counselor testified to the court, daughter would like to have an 8-6 schedule with dad. At another point, the daughter testified, or the counselor testified, that the daughter wanted more time with dad. Now the relationship with the son had changed for the worse from the time of pleading to the time of trial. I mean, that doesn't mean there's an absence of an argument father can make for wanting, I think the way he phrased it was custody or 50-50 joint custody. I mean, he had a great relationship with his daughter, and she wanted an 8-6 schedule with him. That undercuts, that's what I'm arguing, the 6A. That's just one many examples. I do think to finish up, we get back to, I agree with Mr. Kornberg, the facts matter, the law matters. I mean, to suggest that stand back, when it used the phrase, the second part of that statute is inapplicable, to suggest logically you could take that second clause of the second part and we somehow say, well, stand back said the whole second part was inapplicable, but we're going to make the second clause of the second part applicable to custody actions. That's not logical. And I think that argument flies in the face of what Standback's saying and what Standback said the legislature intended. And with that, I would ask your honors to reverse the trial court. Clear if you have any other questions for me.
Okay, any questions from Judge Murphy or Gore? If not, we'll take it under advisement. Thank you so much for your arguments, and I hope the WebEx wasn't too bad. We could hear you fine from I could hear you fine from my end. So with that, I'll ask the clerk to adjourn court.
Thank you, Your Honor.
Thank you.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you, guys.
Thanks.
Thank you, Judge.
Make sure I hit the X before I say something.